Do you ever get some little one-liner text that has information and you just missed it because you've got so much information? I want to look, since I have some time, it's Thanksgiving Day night. I thought that I would probably look up something that I've never seen before. So I'm gonna have to find some peace of mind. All right, let's get out of Facebook. We're gonna go to, what was it called again? Code of Federal, what? Federal Regulations? Rule number, what was it again? Let me see. $67. I thought it was. I just didn't want to put in the wrong one. You are screen sharing. Okay. Hey, documentation of vessels. I wonder if that's what it is. Code of Federal Regulations, part 67. I guess there's a lot. I guess you'd need to know what the Code of Regulation, Federal Rules of Civil Procedure. Oh, let me try that. What was it? Federal Rules of Civil Procedure. Let me see what that would be. But that one looks like a good one. Everybody remember 46 CFR. Oh, let me write that down. Oh, I'm running out of paper around here. Oh, that's the scratch paper. The things that I write down when they look interesting. 46 CFR part 67. So we'll look at that. But first I gotta get this right. Federal Rules of Civil Procedure. Okay, let's try this. Want to make sure that I have the right one. Federal Rules of Civil Procedure. They've got so many swarms of hither offices that I don't know at all. Hey, there it is. Rule 67. Deposit into court. Now that sounds really good. Well, you know, because the court is a bank, right? Yeah. Money judgment, sum of money or other deliverable thing of party. Okay. Let's read this. Rule 67, deposit into court. Depositing property, if any part of the relief sought is a money judgment or the disposition of a sum of money or some other deliverable thing, a party on notice to every other party and by leave of court may deposit with the court all or part of the money or thing, whether or not that party claims any of it. The depositing party must deliver to the clerk a copy of the order permitting deposit. So I guess sending it to the CFO, your GSA bonds, is probably not the thing to do. But I did try to give that to the clerk, the GSA bonds, I remember. And he handed it back to me and he walked around and he closed the door. Like he acted like he was going to go to the bathroom or go to lunch. I thought it was strange. I should have done it again. I think I did. I think I did it twice. I should have done it 3 times. That's interesting. So investing and withdrawing funds. Money paid into court under this rule must be deposited and withdrawn in accordance with 28 USC. Let's write this one down. 28 USC 2041 and 2042. I think I've seen that before. And any like statute, the money must be deposited in an interest-bearing account or invested in a court-approved interest-bearing instrument. As amended December 29th, 1948. This rule provides for deposit in court generally. Continuing similar special provisions contained in such statutes as USC Title 28, 41, 26, now 1335, 1397, and 2361. Original jurisdiction of bills of Interpleader. Oh, how do you plead? Oh, and of bills in the nature of Interpleader. See generally Howard versus United States, 184 U.S. 676, 1902. United States Supreme Court Admiralty Rules, 1920. Rules 37, bringing funds into court. 41, funds in court registry. And 42, claims against proceeds in registry. With the first sentence, compare English rules under the Judicature Act, the annual practice, 1937. Okay, that was Notes of Advisory Committee on Rules 1937. Now this is Notes of Advisory Committee on Rules 1948 Amendment. So they amended it. The first amendment substitutes the present statutory reference. Since the Act of June 26, 1934 was amended by the Act of December 21st, 1944, 58 Statute 845. Correcting references are made. Notes of Advisory Committee on Rules 1983 Amendment. Rule 67 has been amended in 3 ways. The first change, they sure do make a lot of changes, don't they? They hide things, don't they? The first change is the addition of the clause in the first sentence. Some courts have construed the present rule to permit deposit only when the party making it claims no interest in the fund or thing deposited. However, there are situations in which a litigant may wish to be relieved of responsibility for a sum or thing, but continue to claim an interest in all or part of it. In these cases, the deposit in court procedure should be available, in addition to the advantages to the party making the deposit. The procedure gives other litigants assurance that any judgment will be collectible. The amendment is intended to accomplish that. The second change is the addition of a requirement that the order of deposit be served, here it is, on the clerk of the court in which the sum or thing is to be deposited. This is simply to assure that the clerk knows what is being deposited and what his responsibilities are with respect to the deposit. The latter point is particularly important since the rule as amended contemplates that deposits will be placed in interest-bearing accounts. The clerk must know what treatment has been ordered for the particular deposit. So in reading those two paragraphs, either you're going to say that you don't want interest, or you say that you do want interest. Is that what treatment we're talking about? The third change is to require that any money be deposited in an interest-bearing account or instrument approved by the court. Committee notes on Rules 2007 amendment. The language of Rule 67 has been amended as part of the general restyling of the civil rules to make them more easily understood and to make style and terminology consistent throughout the rules. These changes are intended to be stylistic only. Receivers up, receivers. Oh. Let's look at Rule 68. These are rules, apparently. Offer of judgment. Making an offer. Judgment on an accepted offer. At least 14 days before the date set for trial, a party defending against a claim may serve on an opposing party an offer to allow judgment on specific terms with the costs then accrued if within 14 days after being served, the opposing party serves written notice accepting the offer. Either party may then file the offer and notice of acceptance plus proof of service. The clerk must then enter judgment. B, unaccepted offer. An unaccepted offer is considered withdrawn, but it does not preclude a later offer. Evidence of an unaccepted offer is not admissible except in a proceeding to determine costs. C, offer after liability is determined. When one party's liability to another has been determined, but the extent of liability remains to be determined by further proceedings, the party held liable may make an offer of judgment. It must be served within a reasonable time, but at least 14 days before the date set for a hearing to determine the extent of liability. D, paying costs after an unaccepted offer. If the judgment that the offeree finally obtains is not more favorable than the unaccepted offer, the offeree must pay the costs incurred after the offer was made. Notes of Advisory Committee on Rules for 1946 Amendment. The third sentence of Rule 68 has been altered to make clear that evidence of an unaccepted offer is admissible in a proceeding to determine the costs of the action, but is not otherwise admissible. The two sentences substituted for the deleted last sentence of the rule assured a party the right to make a second offer where the situation permits. As for example, where a prior offer was not accepted, but the plaintiff's judgment is nullified and a new trial ordered, whereupon the defendant desires to make a second offer. It is implicit, however, that as long as the case continues whether there be a first, second, or third trial, and the defendant makes no further offer, his first and only offer will operate to save him the costs from the time of that offer if the plaintiff ultimately obtains a judgment less than the sum offered. In the case of successive offers not accepted, the offerer is saved the costs incurred after the making of the offer, which was equal to or greater than the judgment ultimately obtained. These provisions should serve to encourage settlements and avoid protracted litigation. The phrase "before the trial begins" in the first sentence of the rule has been construed in Cover versus Chicago Eye Shield Company. Construed to what? Notes of Advisory Committee on Rules 1966 Amendment. The logical extension of the concept of offer of judgment is suggested by the common admiralty practice of determining liability before the amount of liability is determined. Oh. So you want to say who the person is that's liable before the amount is determined. I gotcha. All right, so here's the Notes of Advisory Committee on Rules 1987 Amendment. Hey, 1987. The amendments are technical. No substantive change is intended. Committee Notes on Rules 2007 Amendment. The language of Rule 68 has been amended as part of the general restyling of the civil rules to make them more easily understood and to make style and terminology consistent throughout the rules. These changes are intended to be stylistic only. Committee Notes on Rules 2009 Amendment. Former Rule 68 allowed service of an offer of judgment more than 10 days before the trial begins, or, you're making him an offer, or if liability has been determined, at least 10 days before a hearing to determine the extent of liability. It may be difficult to know in advance when trial will begin or when a hearing will be held. The time is now measured from the date set for trial or hearing. Resetting the date establishes a new time for serving the offer. The former 10-day periods are extended to 14 days to reflect the change in the Rule 6A method for computing periods less than 11 days. Let's go to 69 execution. Execution, money judgment, applicable procedure. A money judgment is enforced by a writ of execution. I've done that, unless the court directs otherwise. The procedure on execution and in proceedings supplementary to and in aid of judgment or execution must accord with the procedure of the state where the court is located, but a federal statute governs to the extent it applies. 2, obtaining discovery. In aid of the judgment or execution, the judgment creditor or a successor in interest, whose interest appears of record, may obtain discovery from any person, including the judgment debtor, as provided in these rules or by the procedure of the state where the court is located. B, against certain public officers. When a judgment has been entered against a revenue officer in the circumstances stated in 28 USC 2006, or against an officer of Congress in the circumstances stated in 2 USC 118, The judgment must be satisfied as those statutes provide. A revenue officer. Let's go there. 28 USC 2006. Execution against revenue officer. Execution shall not issue against a collector or other revenue officer on a final judgment in any proceeding against him for any of his acts, or for the recovery of any money exacted by or paid to him, and subsequently paid into the treasury in performing his official duties, if the court certifies that 1. Probable cause existed, or 2. The officer acted under the directions of the Secretary of Treasury, the Director, Bureau of Alcohol, Tobacco, Firearms, and Explosives, Department of Justice, or other proper government officer. When such certificate has been issued, the amount of the judgment shall be paid out of the proper appropriation by the Treasury. That's what we want. We want judgments and we want to be paid. Oh, what is that? Imprisonment for debt. We don't want to be debtors or admit to be debtors, that's for sure. Hey, now look at this. It says a person. That's the construct, okay, you guys? That's not you and me. That's not the living woman. That is a person. That's that construct thing. A person shall not be imprisoned for debt on a writ of execution or other process issued from a court of the United States in any state wherein imprisonment for debt has been abolished, All modifications, conditions, and restrictions upon such imprisonment provided by state law shall apply to any writ of execution or process issued from a court of the United States in accordance with the procedure applicable in such state. When they say a court of the United States, that's Washington, D.C. United States is Washington, D.C. So that's federal government. B, any person arrested or imprisoned in any state on a writ of execution or other process issued from any court of the United States in a civil action shall have the same jail privileges and be governed by the same regulations as persons confined in like cases on process issued from the courts of such state. The same requirements governing discharge are applicable in such state shall apply. Any proceedings for discharge shall be conducted before a United States magistrate judge for the judicial district wherein the defendant is held. Discharge is good. Next. Sale of personality, generally. This is interesting. 28 U.S. Code 2004. Any personality sold under any order or decree of any court of the United States shall be sold in accordance with Section 2001 of this title, unless the court orders otherwise. This section shall not apply to sales and proceedings under Title 11 or by receivers or conservators of banks appointed by the comptroller of the currency. I don't even know what I'm reading, but let's look at this 2001 Sale of Realty generally. Any realty or interest therein sold under any order or decree of any court of the United States shall be sold as a whole or in separate parcels at public sale at the courthouse of the county, parish, or city in which the greater part of the property is located, or upon the premises or some parcel thereof located therein, as the court directs. Such sale shall, boy, can you say S's that many times? Such sale shall be upon such terms and conditions as the court directs. Property in the possession of a receiver or receivers appointed by one or more district courts shall be sold at public sale in the district wherein any such receiver was first appointed, at the courthouse of the county, parish, or city situated therein, in which the greater part of the property in such district is located, or on the premises or some parcel thereof located in such county, parish, city, as such court directs, unless the court orders the sale of the property or one or more parcels thereof in one or more ancillary districts. That sucks. It's like when you're having your stuff sold. Hate that. B, after a hearing, of which notice to all interested parties shall be given by publication, or otherwise as the court directs. The court may order the sale of such realty or interest, or any part thereof at private sale for cash or other consideration, and upon such terms and conditions as the court approves, if it finds that the best interest of the estate will be conserved thereby. Before confirmation of any private sale, the court shall appoint 3 disinterested persons to appraise such property, or different groups of 3 appraisers, each to appraise properties of different classes or situated in different localities. No private sale shall be confirmed at a price less than 2/3 of the appraised value. Before confirmation of any private sale, the terms thereof shall be published in such newspaper or newspapers of general circulation as the court directs at least 10 days before confirmation. The private sale shall not be confirmed if a bona fide offer is made, under conditions prescribed by the court, which guarantees at least 10 per centum increase over the price offered in the private sale. C, this section shall not apply to sales and proceedings under Title 11 or by receivers or conservators of banks appointed by the comptroller of the currency. Interesting. So these are just things that you can read. If it applies to you, then it applies to you. We were looking up, I wrote down 28 USC 2041. Let me just look at that for a second. So how do you do this? Here's a US code, 28 USC. Enter title. Is it the number? 28. Section 2041. go? Oh, that's that deposit of monies in pending or adjudicated cases. All monies paid into any court of the United States. Okay, because it's a bank. Or received by the officers thereof in any case pending or adjudicated in such court shall be forthwith deposited with the treasurer of the United States or a designated depositary in the name and to the credit of such court. Interesting. This section shall not prevent the delivery of any such money to the rightful owners upon security, according to agreement of parties, under the direction of the court. Let's go back a second, because I saw, look at all this stuff right here. US Code. You got the general provisions, the Congress, the president, flag and seal, seat of government in the states, government organization and employees. Oh, Title V. That would be a really good one to do a video on. Then we've got Federal Advisory Committee Act. Title 5A. Then Title 6 is Domestic Security. Title 7 is Agriculture. Title 8 is Aliens and Nationality. Title 9 is Arbitration. Title 10 is Armed Forces. Title 11 is Bankruptcy. And 11A is Bankruptcy Rules. Then Title 12 is Banks and Banking on Title 12. Title 13 is Census. Title 14, Coast Guard. Title 15, Commerce and Trade. Title 16, Conservation. Title 17 is Copyrights. Title 18 is Crimes and Criminal Procedure. Title 18A, Unlawful Possession or Receipt of Firearms. Title 19, Custom Duties. Title 20, Education. Title 21, Food and Drugs. Title 22, Foreign Relations and Intercourse. I've heard that. Because we're foreigners, we really are. We're not US citizens. US citizenry is the made-up citizen of Washington, D.C. to pay the taxes. You can look up Title 26. Look, it's going to be right here. Internal Revenue Code. And you can look up the definitions under 1770? Look up the definitions of Internal Revenue Code. It'll tell you. I'm getting tired. I think it's the tryptophan. Yeah. Even though I don't remember eating turkey today. I must have ate it yesterday. I'm tired. But you can read all these different ones. Look at Money and Finance, Title 31. So if you ever want to look up stuff, just Google it like they tell me in the university. Have a question, just Google it. Well, why am I here? You have to ask yourself that. Okay, I'm out of here then. See ya. I'm just going to go to Google from now on then. Ridiculous. Yeah, I don't need any more degrees. I got 4. I don't need any more. Probably have 5 and just don't have that last certificate. But anyways, hey, Veterans Benefits Postal Service. You know, there's a lot of things that we could probably read here. War and national defense. Voting and elections. National Park Service and related programs. Public lands. Just a lot of interesting things here. So if you ever want to find out more information, Legal Information Institute. LII. That's law.cornell.edu. Just look up the titles and then go to those, and then you can have more wisdom to know how to deal. All right, good night.